Good morning. We're just going to let everyone get logged on this fine Thursday morning. Good morning. I should have music playing. Gonna give it to 9:02 and then we're going to get started. I hope you all have your coffee. If not, go get it. All right. Well, good morning. And welcome to the Napa Valley Grape Growers Business of Vineyards seminar, focusing on lease agreements. My name is Emily Hegarty. I'm the program director here at the Napa Valley Grape Growers and the Farm Worker Foundation. And I'm going to give you a soft launch in with some housekeeping slides. So first and foremost, I'd like to thank the people and businesses that help make this event and all our events possible, the speakers for their time and expertise, along with our annual sponsors that you see on the screen. I encourage you to support these businesses as they support us and believe in our mission. Next, we're going to cover our little Zoom rules. So all attendees, as you log on, will see that you're muted. As each presenter speaks, you're welcome to put questions into the Q&A box that you see at the bottom of your screen. Please try to remember the Q&A part of that box and put those questions there instead of the chat, which we ask that you reserve just for technical difficulties. And finally, at the end of our presentation, when Zoom closes, you'll get a little pop-up on your screen that will ask you to take a brief survey. This is just so we can keep track of your needs and what you are looking to receive from your membership with the Napa Valley Grape Growers. So please fill out that information. So now let's jump into it. I am thrilled to welcome our speakers, Carol Kingery Ritter and Jennifer Douglas, both managing partners from DPNF, who are also annual sponsors. Carol practices in the firm's business and real property practice groups. Her practice includes general corporate formation, compliance, and restructuring, along with business contracts with an emphasis on wine industry businesses. Very appropriate. Jennifer is the head of the firm's labor and employment department, and her extensive experience in include all matters of employment issues, including wage and hour, discrimination, reasonable accommodation, leave of absence, and implementing state and federal regulations. Needless to say, you have two people that definitely know their way around a contract. So Carol, with that, I will stop talking, stop sharing my screen, and I'll let you take over. And you are on mute.
Thank you very much. Happy to be here again. Let me share my screen for my presentation. Let's see. There we go. So Perfect. We spoke last, I think a few months ago, about grape contracts, and that conversation was prompted, again, from a reaction to wildfire impacts on grape contracting and managing the conflicts that have arisen and may arise again in the future, or expected to arise again in the future. And from that, the grape growers reached out and said, our members are interested in talking more about vineyard leasing, which would be a mechanism to shift risk, which is an area that's come up a bit. So how we got here to this conversation today, again, wildfires and climate change are changing the risks of farming and of winemaking. Growers are looking for ways to mitigate the risks and losses associated with wildfire impacts. And wineries are also looking for ways to mitigate the operational impacts of decreased inventory or potential damage to brand value. That typo will be fixed as a result of quality impacts. So the question is, do leases present an opportunity to find goal alignment regarding risk allocation and quality control? In my opinion, that's a yes. Leases are a great opportunity to reevaluate where risk is shared or where risk is shifted. And California law provides a great amount of latitude for structuring grape contracts as a very broad, or sorry, not grape contracts, vineyard leases. As a very broad parameter, the California Subdivision Map Act creates a limitation on leasing any land that is not a full legal parcel, with the exception of agricultural leases, which means that a piece of land that may have many different improvements, many different blocks, many different uses, the agricultural uses can be carved out and leased between parties without any prohibitions at the California law level that would render those contracts unenforceable or void or against public policy. So as a beginning premise, that provides a lot of opportunity to decide what it is that we're leasing. So that is the first question of where we start. If you want to lease land, if you're a grower, you want to lease land to a winery, or you're a winery that wants to propose shifting from a grape contract structure to a vineyard lease structure, the first question is, what are we going to lease? And that can be defined almost as small as a vineyard block. Actually, it could be defined as small as a vineyard block. Of course, the practical aspect of that is a farming and fish efficiency question. But as far as what you're leasing, it would be the vineyard. And that would also need to include the elements or access to the elements, if not the elements themselves that support that vineyard, being access, the utilities that drive your pump, access to the well, to water. Potentially there's also, barns or other accessory structures on the property or a reservoir. All of that can be narrowly and specifically tailored to create a leased premises that covers the agricultural use that would shift from the possession and control of which would shift from the landowner to the tenant. When we talk about defining what the leased premises is, wisdom would also suggest that as the party leasing and as the party the party leasing out and the person who is doing the leasing, both to be doing their due diligence to know not only what is it that is a part of our leased premises, but what is the quality. And the areas of due diligence are pretty obvious. The first one is, what is the quality of this vineyard that is going to be leased? That will drive pricing, which we'll talk about a little bit in a bit here. But it will also impact covenants that may need to be incorporated into that lease regarding the ongoing care of that vineyard and the quality of the vineyard that the owner will want to see at the end of the lease, and the quality of the vineyard that the tenant is expecting to receive in consideration of paying rent. So vineyard condition is, of course, one. Water resources. What is the quality of the water available to irrigate the vineyard? What is the quantity of water available to irrigate the vineyard? Where does it come from? Are all of those rights clear and well defined? Is there an ongoing obligation to report if that's state water or riparian water? And who's going to take that obligation? Is that all up to date? So as a tenant, if we're leasing, we know that those water rights are good and durable for the term of the lease. In addition, Access, making sure that's clear. We're not going to have any disputes in the future. We'll talk about long-term leases and whether or not replants will be contemplated as a part of a vineyard lease, but taking a look at ECPs and making sure that the vineyards that are leased are planted within an ECP if the slopes would require it. That's a general areas of due diligence that should be considered before, as an owner, before leasing out the vineyard, so you don't get caught by surprise. And as a tenant, the areas that you're going to want to take a look at as you're negotiating out that lease. Due diligence, of course, can extend beyond those basic elements, depending on the term of the lease and what the risk, risk profile is of the tenant. A lease can run for a long time, so much that it will appear that ownership fundamentally has shifted. We'll talk about that issue also from a property tax perspective. But for longer term leases, other due diligence that should be considered is pulling a title report so that you can see what type of encumbrances, especially financing encumbrances, are on the property, and whether a SNDA, subordination, non-disturbance, and attornment agreement should be acquired from lenders to make sure that a lease wouldn't get wiped out in the event of a foreclosure. And then, of course, other environmental diligence and potentially certification diligence too, if the vineyard is certified as organic or Napa Green or fish friendly. The second element of diligence and negotiations from a starting point to take a look at is if the grower is looking at shifting from a GPA structure. Oftentimes, those GPAs are not all one-year GPAs that are just going to roll out and terminate at the same time, which means that if you're looking at leasing an entire vineyard, you may be in a position of requiring the tenant to assume the obligations to perform the requirements of GPAs until those GPAs can be terminated or wound down, or their evergreen provisions noticed to start rolling out. So that's an important element to take a look at. Also, if there's a long-term plan, not this year or next year, but if this is if you're looking at a strategy of shifting over time to leasing, how should you look at your GPAs now? What type of terms should you be looking at? Should you be noticing the rollout of an evergreen, and also taking a look at the assignment provisions of your grape contracts to see what types of notices or triggers might be caused upon an ownership, a change in the farming or control of the vineyard itself. We talked about point 3 here, this condition of the vineyard asset. This will really drive questions of long-term and short-term leasing. And then the big question is whether or not this vineyard is going to be maintained, or whether it might be replanted or redeveloped during the term of the lease. On who should conduct due diligence. Both, again, I think as an owner of a vineyard, you want to make sure that you are prepared to present the condition, to know and present the condition of the vineyard in a way that can be reflected accurately in a contract and allow you to arrive at the right terms, regard the economic terms, but also, again, other covenants that will apply to that lease. So talking about short-term leases, a short-term lease will in a lot of ways look very similar to an acreage-based grape contract, except that in this instance, you would be shifting the farming responsibility fully to the tenant. So at that point, tenant hires their own farm labor contractor or has their own winery crew that is going to come do all of the farming. And you will have a fixed, usually a short fixed term. Maybe this is an opportunity to look and see how this works. Maybe with a few options to extend. Options to extend are tenant rights. So that's an important point to keep in mind as a landlord. It's not a landlord right. That would be essentially a mutual agreement to extend later rather than an option that a tenant holds. The rent is probably one of the most interesting portions of the negotiation of a vineyard lease. And we'll talk about it both in the short and long-term context, and but the conversation will probably be redundant. So rent can be a simple fixed price. Usually that price is tied to planted acreage without additional consideration to, the ag roads, access roads, accessory areas, unless there are structures involved. There's an opportunity to rent barns to store equipment, et cetera. So usually we're looking at a price per acre. That would be a fixed price. That would be for a landlord, the lowest risk structure. Landlord gets paid a specific price per acre every year. That fixed price can be adjusted either by a CPI adjustment or tied to the fluctuations in the grape crush report. But that's a fixed price that will not vary at all as the crop varies. So in a bust crop, in a boom crop, it won't matter, landlord gets the same price. In a crop share or hybrid structure, it's a little bit of both. So landlord might get a very modest fixed price per acre, call it $500 per acre, but then they also get a percentage of the gross receipts from the sale of those grapes, either to a third party or grapes that the winery tenant uses itself based on an agreed pricing formula. So that is a middle of the road where if there is a large valuable crop that the landlord may have an opportunity to share in the upside and also take some of the downside risk, but it's mitigated by that fixed rent portion, unlike where a landowner would sit today under a grape purchase agreement structure, where they're paying farming and have all the risk of the crop in a much broader sense. Yes.
You saw my face and you had a question. Yeah. Just a quick one, since we're on the slide. Is per acre vineyard acre or assessment acre? Sorry, that's a lot of the word acre in one sentence.
Oh, so per acre of actual vineyard versus the entire parcel? Is that the question?
Per acre vineyard is per acre vineyard acre or assessment acre?
Yeah, vineyard acre. So usually that is the way that a rent, the most common way for vineyard lease rent to be structured. So if I have a 60-acre parcel and only 15 acres of that are planted, then the rent is going to be based on that 15 acres that generates revenue. The rest of that property doesn't generate revenue. I would say the exception there is if there's some other use or value in that additional land, or also what might come into play too as a part of the lease negotiation, are there obligations that go with the rest of that land? Are there important maintenance issues that you want the tenant to be responsible for? In which case, that may adjust the pricing, but not to the landlord's favor in that sense. Hi, Emily.
Hi. Does it include vineyard roads and lanes or not?
Yeah, so usually, that's a really good question. How we talk about vineyard acres, there's different methodology. And of course, it will be impacted by density and, the way that, the vineyard acre of a trellis vineyard is going to have a lot fewer vines than a valley floor. Not a trellis, a terraced vineyard is going to have a lot fewer vines per acre than a valley floor, but generally the vineyard rows are all included. And the perimeter to a certain distance outside of the vines, but not all of the other ancillary roads. And really how you get to, in some senses, it probably doesn't matter too much how specific you are depending on the circumstances, because how you start looking at rent is based on historic revenue. So if within your 15-acre vineyard, you know that your overall crop is 4 tons per acre, and the value of those 4 tons, if you got 4 saleable tons, would be, $10,000 a ton, then those are the economics that you're looking at to help get you down to that price per acre. So that's where the specifics about density and planting and the width of your avenues and the distance between your vines kind of washes out a little bit in the mechanics.
A follow-up would be, how do you determine rent per acre for planted and plantable acres?
Yeah, so plantable is, I want to talk about that in specifically in development leases, and because there are a lot of issues to discuss on development leases. And there are also, you can again have a hybrid model where you may have a vineyard that you have 10 acres that are, you're in your 8th leaf and they're solid. That is a vineyard in the prime of its life. But you might have your other 5 acres if you were going to continue farming, you were planning to replant them in the next few years. So again, your lease is going to need to address both of those issues. It's going to address the value of those blocks that are in their prime. And then it's also going to need to address the obligations to replant and who bears that burden. And frankly, that's probably going to be where the meat of the negotiation would be. And will also impact the term. Here we're talking about short-term leases. So a tenant isn't going to absorb the cost of replanting blocks of vineyard for the short term, because they'll never be able to make the return on that capital investment for that planting. So we can talk about that a little bit more in the long term. In terms of pricing, how do I know what the rent should be? It's highly variable. We often work with appraisers to help us help guide our clients to come up with the right price. There's a general rule of thumb that it's sort of the 1/3 rule, which is assume that if your revenue off this vineyard is $500,000 a year, let's use $600,000 a year to make math for lawyers a little easier. If your general average revenue is $600,000 a year, you assume 1/3 of that is going to cover all of your farming fixed costs. 1/3 of that could go to landlord. 1/3 of it should be held by the tenant for the opportunity and the risk that they undertook in farming. So that's, I would say, a general rule of thumb about pricing, but certainly variable depending on the vineyard and the specifics of the land and the assets.
Okay, well, 2 more questions and then we'll let you move forward.
Okay.
Quickly, what is the typical term of a short-term lease?
So I would consider a short-term lease anything 10 years or less, but it could be 1 year. And particularly if, as a grower, you're looking to evaluate whether or not this works. Whether this works for you, it works for your land, it works for your strategy in terms of holding the asset or passing the asset down, maybe. It could be 1 year. And it also really depends on your tenant, what your tenant's looking for. Is your tenant looking to establish a longer term supply of these grapes, maybe for a particular bottling or a particular project? But I would say short term, in my mind, is less than 10. Long term is 10 to 35.
You want to grab that?
No. The question is, do I know how to turn it off in my office that I don't
go to
work at anymore?
Okay, last
Since I
question.
forgot how to use my phone. Sorry.
What are typical crop share percentages in Napa Sonoma? Do you know that answer?
Oh, so that's really variable. And it depends on also what the fixed rent, how much of that value you push into fixed rent, and really how much of that risk and benefit you want to share. So I would say that's really, in my view, and the contracts that I do are really variable on that point, as to how much that percentage is negotiated in.
All right, I'm gonna pop off the screen, let you keep going.
Okay.
Thank you.
Sounds good. Good questions. Thank you. On other kind of short-term lease terms to think about, of course, insurance. We want to make sure everyone is properly insured for the risk of what might happen on the property. Speaking to crop insurance specifically, a tenant has the ability, and under a vineyard lease, to get a crop insurance policy. It will require cooperation with the landowner to do it, in particular, in order to be able to provide the information necessary to determine, the average yields that are capable of being insured under the policy. Water, water needs to be looked at in a short-term lease, and particularly in a long-term lease. In a long-term lease, we might be thinking more about the risk of a potential failure of a well, replacement. That capital expenses in long-term leases are particularly important, but they're important here too in short-term leases. Where does the water come from? Is the supply secure? If there's compliance related to water, who's going to bear that obligation? Taxes, if the tenant pays taxes, we're looking more at a triple net type lease structure. In short term, I would say, landowners often continue to pay taxes, or there's a split. I'm sure you're familiar with your tax bill that has a land element and a growing improvement element and a structure improvement element. So growing improvements would be an easy property tax element to take a look at and say, hey, tenant, this part's on you. Landlord may maintain responsibility for all of the land assessment, which would be the lion's share of the property taxes on the property that are applicable to the lease, or there can be a proration. One element to look at in taxes, again, probably more important in a long-term structure, but should be considered nonetheless, is if there is a change of ownership of the landowner, of the landlord, then there could be a significant reassessment to current values. Also, particularly if there isn't a Williamson Act contract in place. And, it's tough to be a tenant and be surprised with a property tax bill that goes up exponentially as a result of a change in ownership. Maintenance, these are the issues of our covenants. Again, how do we expect the tenant to care for our vineyard? According to what standard? And what do we expect to be maintained? That should all be clearly defined in the lease, so everyone knows, where their obligations end and the other party's obligations start. In long term, so going back, just circling back here to property taxes. In California, there are limited circumstances when your property will be reassessed and the value increased for a change of control. Obviously, if you sell, or if there's a change in the majority ownership of your LLC that owns the property. But also if you enter into a lease that's 35 years or longer, that is considered a change of control that will trigger a property tax reassessment. That 35 years takes into account all possible options to extend under the lease. So for example, if you decide to take your long-term grape contract that has a 3-year evergreen period and just plug that language into your lease, you don't cap the rolling of that evergreen at 34 years or something short of 35 years, then you've entered into a lease of 35 years or longer, and that will reassess your property taxes. That would be a very unwelcome surprise. So that's something to keep in mind. Again, on the rent structure here, again, as I recalled, a lot of this is very duplicative of what we talked about earlier. Periodic adjustments, though, is maybe a more interesting question in a long-term lease, as to whether or not this long-term lease is really structured as a triple net lease where a tenant has control over almost every aspect of the property. Is this a situation where a CPI, cost of living type adjustment, is appropriate for rent rather than the potentially broader fluctuation of the Great Crush Report? That's definitely a conversation that should be had. What is the right measure of adjusting that rent? And triple net. So again, in a long-term lease, you're more likely to see a very hands-off triple net structure where the tenant really has the control and the responsibility over the property. That would be even more so the case if there is development or redevelopment considered here. And again, you may have, in the earlier example, you may have a hybrid structure where a portion of your vineyard is, so fresh and so clean and, perfect for, the next 20 years, 25 years. But you may have vineyard blocks that really are in need of redevelopment, or you may have a tenant who doesn't want the varietal of a few of your blocks and wants to replant. Those are important considerations to address. If, as a landlord, you want the tenant to bear the cost of that capital expense of replanting, you should expect that the vineyard lease will have to be of a long enough duration that the tenant will be able to recapture or receive the benefit and the value of the substantial cost of redeveloping a vineyard or planting a vineyard, which we all know is a big number here. So that is going to be that will drive term issues. You should also expect, as a landlord, that while there is no crop off that replanted block or replanted or developed vineyard, that rent will be different. You shouldn't expect that rent will be at the same level as your vineyard blocks in their eighth leaf. So oftentimes that rent will tier back up again. It may be zero during the first couple of years, or it may slowly adjust back up to the level of the rest of the vineyard. That may change if there's going to be a cost sharing structure between landlord and tenant for the redevelopment, and all of that is negotiable. A particularly important point for landlord and tenant is choices, viticultural choices. What will be the varietal, the clone? How will this vineyard be developed? And in this case, if there is a situation where a landowner is considering leasing out a vineyard for redevelopment, you want to make sure you're really comfortable with who's going to be making those decisions on the tenant side, or that you have your own consultant who can sit down with the tenant's viticulturalist and make those decisions together. And probably a good idea to do that before you sign the lease, to make sure that there's a good working relationship and alignment. On ECPs, I mentioned this in the due diligence component, we want to make sure that the ECP boundaries line up with the vineyard boundary, so that if there is replanting that needs to occur during the term, there's not a permitting cleanup issue that needs to be addressed. And also you want to make sure to clearly identify who's going to be responsible for the permitting for any replant. Well replacement. So I mentioned this earlier. This is another big capital expense that should be considered in the same way as a replant. If a new well needs to be dropped, what are the potential outcomes of that? Who pays for that work? What if it's not successful? Where can that well be placed? Are there other uses on the property that could be interfering, or that someone might be concerned are interfering? That's an important negotiation. Does it give rise to termination rights on behalf of the tenant if there's no water? It's hard to farm without without water. So whose responsibility and risk is that going to be to bear over a long-term lease? And then commercially viable life of improvements. We've talked about that a lot. Assessment, change in ownership. We addressed that there in the short-term lease section. Again, that's really relevant, particularly in the long term. If there's going to be a change of ownership in the landlord property owning entity or with the property owner, then who bears that step up in property taxes that will result. I think this is maybe, yes, this is my last slide. Let's see. Okay. So just some overlooked provisions that are really relevant here. Damage and destruction. So if there is a fire that burns all of the end posts around the east side of your vineyard, who's responsible? This is again a situation where insurance may or may not be adequate, but we want to be specific about who is insured, or if not, who has the obligation to make these repairs, whether or not destruction will allow for a termination event, and if so, what level of destruction? What percentage of the vineyard is destroyed? Should that allow a tenant to terminate and say, this is no longer the use, I cannot use this vineyard in the way that it was intended. My process of farming 5 acres is totally different than my process for farming 15 acres, and the economics change. Or this should all be redeveloped at the same time. At what point does damage and destruction alter the deal significantly enough that it can't just be repaired, but we need to take a look at the lease as no longer functioning? And then what is the exit? How does that separation look when that happens? Again, well and water impacts. When there is a water shortage or a drought, is there anything that we need to consider beyond just the loss of a well or the replacement of a well and the cost and sharing of that? The water resources, metering if there are shared uses, if there's a residence on this parcel that shares the same well, or if there are wells on the property, one of which is suitable for watering new vines because of its quality, but others aren't. All of these water resource issues of quality and capacity storage need to be considered, as well as the obligations for any reporting ongoing, so that everyone knows what is in their bucket of responsibility and who's accountable if someone fails. Landlord use and access, again, this is a shared use question. Maybe landlord's only leasing out half the vineyard. So how will the parties work together? Does it matter that you use or not use the same farming company for efficiency purposes? It may change the economics if a landlord leases out half a vineyard and for the first few years the tenant wants to use the same farmer but then changes their mind. So what happens then? Also, generally, an owner will have access to the vineyard as long as it's not interfering with the access and the use of the tenant, which is at this point primary. If you're leasing your vineyard, that tenant use, their possession and control is really primary at that point as a part of the shift from a grape contract to a vineyard lease. Vineyard designates. So a vineyard designation, a name for a vineyard, is really fundamentally a trademark. And if there is a vineyard designate, who owns it? How is that use allowed or not allowed? How are the quality control components of the license of a vineyard designate trademark codified to make sure that the owner of that vineyard designate can protect that trademark going forward? What happens if a tenant decides to name a vineyard and trademark it? What does that mean? Maybe that's fine and it's a trademark, and when the lease ends, it's just a trademark. It doesn't necessarily have to apply to your vineyard. But if there is a name to your vineyard, and if there is an important component here of trying to improve the value of your vineyard through its name, then that also needs to be addressed in the vineyard lease. And then finally, employment practices, which is where I'm going to segue to my partner, Jennifer Douglas, to address this other area of risk that needs to be dealt with. But overall, just broadly stepping back, as a concluding remark, vineyard leases are very flexible and malleable. There is not a lot in California law that will tell you what has to be in your vineyard lease. The parties are free to be creative, but its fundamental purpose is to shift risks. And with that, that also changes economics. So those need to be balanced out together in the negotiation and where you end up. So with that, Jen, you can steal the screen.
Okay, thanks, Carol. All right, so I am going to switch over to mine. All right. So thanks for the segue, Carol. And we are going to now talk about the employment issues with vineyard leasing. So why worry about employment issues, right? So Carol has gone through all of the different factors and things you need to consider in developing your vineyard lease. And of course, as the lawyer that specializes in employment, of course, I think employment issues are the number one thing that you should be concerned about. But of course, it's only one of many. But why it's important, first of all, is because of money. Employment costs are probably your number one expense in a business that has employees. So certainly knowing who's responsible for those employees in your vineyard lease is going to be important. Additionally, brand. So if you have employment issues that come up, negative press concerning your employment could affect your brand, could affect your public relations. It can also affect your reputation in the community. In Napa Valley and in Sonoma, it's very difficult to find quality labor. So if you develop a reputation of having poor employment practices, it's definitely going to affect your brand. It's going to affect your reputation in the community. So it's important to pay attention to those issues and make sure who's responsible for them and who's going to make sure that the responsibilities are carried out effectively. So looking at the employment aspects, there are 4 potential players in a vineyard lease arrangement with respect to employment. So you have the landlord, and as the landlord, you may or may not have any employment responsibilities, right? So if you, as the landlord, decide, you know what, I just want to collect money. I don't want to have anything to do with farming anymore. I don't care about collecting any profits from the grapes. I just want to collect a check. In that scenario where you have absolutely no control over the vineyard, you've completely turned it over to the grower or the tenant to go ahead and do what they will with the vineyard, your liability for employment will be 0. Now, it is very rare that that happens. So I caution you, and there's a lot of reasons why you would not do that, right? Do you want to exercise control over your land? You have concerns about the way in which a tenant or a grower might actually affect the value of your land. You do want to retain some of the profits. You do want to retain some of the grapes. So that sort of decision of whether or not you have a hands-off lease is going to be important. The other person is the tenant, which may or may not be the grower. So you have the tenant. It might be a winery that then contracts out to someone else to grow, but the tenant most likely will be the grower. And then the grower may or may not hire a vineyard management company. So the grower may have direct employees that are going to be farming the land, but they also might hire a vineyard management company to manage the vineyard and take care of it and provide the labor. And then, of course, the final player in the employment perspective for a vineyard lease are the actual workers that are working the land.
Jennifer, we still see your main slide. Do you want to progress forward?
Oh, that's
Yeah,
weird.
it's still your.
I am progressing.
Or maybe.
Oh, it says it's paused. I don't know why it's
fun.
paused. Yeah. Oh, resume share. Okay.
There it is.
There you go. Okay. Sorry about that. I've never had a paused share before. Employment practices, so perspective. So we just went through this. This is the landlord I was just speaking about, the tenant, which may or may not be have its own vineyard management. They may have hired a vineyard management company, or they may just have direct employees, and then the workers. So the ultimate question, who is responsible for employment? So it's important to determine who's responsible for the employees working the land. California, as almost all of you on this call probably already know, is a very pro-employee state. It is difficult to navigate the laws, which of course keeps me in practice. So I appreciate that, but I also appreciate the struggles that all of us have in navigating those laws in order to protect our employees and to keep our businesses viable. So in working the land and making sure that the employment issues are addressed, there are several laws that you need to take into consideration. Several years ago, AB 1897 was passed, which may sound familiar to many of you on this webinar. And that had basically codified a joint employer idea or concept in the law that basically if you contract with someone to provide labor, so you contract with a farm labor contractor to provide labor in order for your benefit, you're going to be responsible for wages directly, primarily. You can't, the law is going to say that there's no distinction between you and the primary employer. Now, this is really a codification of a concept of joint employer in California, which is that if you retain the benefit of that labor, you hire a farm labor contractor, a vineyard management company to provide services for your benefit, meaning that you are going to exercise control over how that labor is being done. You're going to receive the benefit of that labor. You're going to be considered a joint employer, and you will be responsible for the employment and wage and hour issues and risks associated with those employees in the event that the other employer doesn't take responsibility for it. Ultimately, in California, the law protects the employee. So if there's any ambiguity as to who is responsible, you will be responsible. So the law is going to find whoever can pay. The employee is going to be protected. So the law looks at this situation as the employee goes onto your land, they provide the labor, they need to be protected and able to collect that money. And if they can't collect it from their direct employer, they're going to be able to look to whoever has been benefiting from their labor. And so that's the concept of this. And so the issue when you're looking at vineyard lease arrangements is how do you manage this risk? If you're not directly paying the employees or supervising the employees, how do you protect yourself from that risk that you might be liable? So that's where the written agreement comes into play. So as you were talking about, as Carol went through all the various aspects that you need to make sure that you're taking care of in your lease, concerning who has responsibility for water, who has responsibility for maintenance, who has responsibility for complying with different laws and regulations. You need to make sure that you are specifying if there's any employment issues between that lease, right? Who's responsible for making sure that the labor is going to be taken care of. Now, your lease agreement may not have anything to do with this. It may be referred to in a separate document, which is going to be your vineyard management, perhaps, agreement. whatever the agreement that's going to be dealing with the employees, it needs to be clearly defined who is responsible for employees, who's paying those employees, who's providing the safe work environment, who's providing the benefits that might be required under the law, who's making sure that the conditions are meeting the legal standards of the law. Clearly define who's responsible. And there needs to be a strong indemnity provision protecting the party who is relying on the other to take care of the employees. So if you, for example, are the tenant, the grower, you hire a vineyard management company to farm your land and provide the labor. In order to do that, you want to make sure there's a strong indemnity provision protecting you so that it's clear in the agreement that that vineyard management company is going to indemnify you if an employee sues you for not getting paid or for not having a safe work environment. Because again, going back to the previous slide, you will be liable. You are on the spectrum of being able to be held accountable for that. The law allows you to shift that responsibility in a written agreement. Now, the last point here is that you do need to know who you're contracting with, right? So that agreement of indemnity is only going to be as good as your person that you're actually contracting with. So the agreement won't protect you if the other party goes bankrupt or skips town. So you need to make sure that if you are contracting with a vineyard management company or a farm labor contractor, that it's someone that you can trust, that it's someone who has a good record for paying its employees and following the law, because those indemnity provisions are not going to protect you if that person is not able to actually pay a judgment if they are sued. Licenses and registrations. So thinking back in the previous slide where I gave you the 4 different layers, you have the landlord, you have a tenant, you have a potential separate vineyard management company, and you have the worker. In the vineyard context, the fact that someone is providing you labor raises the issue of making sure someone is properly licensed in order to do that. You know, when I first started practicing law here, handshake deals were the norm. And I would say we still see handshake deals, but it's definitely not the norm anymore. Written agreements are definitely in place. There has been a concerted effort to transition to written agreements. And part of that is the labor commissioners, the DLSE, which is the California Labor Commissioner, their renewed interest and what's the word I'm looking for? Their efforts to make sure to hold people accountable for the farm labor contractor and holding the grower accountable for making sure that the farm labor contractors are licensed. So with that, there's been a definite effort to make sure that when you are contracting with a farm labor contractor, that you make sure that they are properly licensed and that they're following the guidelines. And so if people that have come to California that maybe have been working in other states are not as familiar with California's stringent farm labor contractor rules, under the Federal Migrant Seasonal Protection Act, MISPA, which is overseen by the Federal Department of Labor, the DOL. Under those guidelines, agricultural employers do not need to be licensed. In California, agricultural employers who render services, who for a fee render services in connection with production of farm products do need to be licensed. So there's a distinction between there. And so if you have doubts about whether or not you need to be licensed when you're in a lease situation, you definitely need to seek legal advice to see whether or not you need to be licensed and to confirm whether your vineyard management company that you may contract with is properly licensed. And even if you as an agricultural employer, say a tenant is not going to be a vineyard management company. The tenant who leases the vineyard is just going to hire their own direct employees. So they're not going to get a farm labor contractor. They're not going to take their workforce and work for other vineyards. Maybe when there's downtime, a lot of companies, A lot of growers might have direct employees that then they will contract with other vineyard or other growers to provide services for their vineyards. And in those situations, once they're doing that for a fee, they are a farm labor contractor. So although they have their own direct employees that are primarily farming their own land, once you work for someone else, you need to have a license. So say that's not the case, you just have your direct employees, you don't need a farm labor contractor license. You do need to apply or comply with MISPA, because all agricultural employees are considered seasonal employees under MISPA, because they work on a seasonal product, right? Grapes are a seasonal product. There are different seasons to the work, and the law considers that to be a seasonal employee. So there are notice requirements that need to be taken care of under MISPA. So again, seeking legal advice regarding compliance is really important. The Napa Valley Grape Growers has a best practices paper that I'm sure they will share with you if it's not already on their website, that can help you at least navigate some of the broader based decisions. So let's look at the risks in general, right? So we talked about the fact that it's important to make sure that you're taking care of the employment issues, that you are assigning the risk in your agreements to make sure that whoever's supposed to be providing the pay checks and pay stubs to employees are doing so, that they're providing the right workplace. What's the ultimate risk in this? So litigation obviously is probably on everyone's mind when they think of employees and the cost. Other than the daily payroll costs, a lot of our day-to-day decisions as employers is meant to mitigate any potential litigation. And in agricultural settings, litigation is significant. There is a risk. Wage and hour litigation is rampant in California. And it's not just individual actions, although that still happens. So you still have individual agricultural workers that will bring wage claims or wrongful termination claims against their employers. Class actions, we're seeing many of class actions for wage and hour claims against agricultural employers. PAGA auctions, however, are the most. A PAGA is a Private Attorney General Act. And if you have not had any experience with PAGA, that is great news for you. But PAGA is the rising class action. It is actually eclipsing class actions. It's a representative action. And what it means is that an individual hourly employee of yours can get an attorney and step into the shoes of the labor commissioner and bring an action against their employer for violations of the labor code. So they could have stolen from their employer and been fired and been the worst employee ever, and they could have only worked for you for 2 weeks. But they can bring a PAGA action on behalf of all of your hourly employees, claiming that you didn't provide meal breaks, you didn't provide rest breaks, you didn't pay them for off the clock work. They showed up early for their shift and started sharpening their tools, and you didn't pay them for that. There are all sorts of violations that they can claim, and it is an expensive action. There's very little defense to it because they're on technical issues. It's not a matter of showing whether or not someone was treated fairly or whether or not someone was a good employee. It's a matter of, was this law technically violated? And if so, there's a penalty, and they stack up, and there's attorney's fees, and it's expensive. And to the point of attorney's fees, if anyone has been involved in employment litigation, it is different than most other types of litigation in the sense that employees can recover their attorney's fees, but employers cannot. So they are very expensive because even if you are 100% right, they will cost you money to defend. And unfortunately, attorney's fees are what drive most litigation in employment contexts. So it's important to stay out of litigation, and to the extent that you can stay out of being responsible for the employment issues altogether, obviously is important. And the only way to do that is through effective written agreements, and then making sure that you're contracting with people that are good employers and that follow the law to the extent that they can. The final litigation, quasi-litigation risk is the agency audits and investigations. So the Department of Labor, which is the federal side, the California Labor Commissioner, Cal OSHA, other agencies may come in, and if you've ever been subject to an audit, sometimes it'll be one agency that will come in. Sometimes they'll band together and they'll all come in together and do a raid on your facility. And it can be extremely intimidating. And while it's not as expensive as an actual lawsuit in California, it is disruptive and it is unpleasant. and it can cost you money as well with citations. So it's definitely something you want to be aware of and stay clear of as well. Union activity, we don't have a lot of unions here in Napa County or in Sonoma County for that matter. There has been rumblings, especially with the advent of cannabis and the requirements in cannabis regulations, that union agreements be considered, that there has been the fear that unions will start to take much more hold in the Valley. That hasn't happened yet, but it's certainly a risk that is out there. And the best way to avoid that risk, obviously, is to make sure that your employees feel like they're being paid properly. So again, part of that, adding on that layer of risk, if there was ever a union brought into your situation with these different layers, that's going to add another layer to those, to the initial slide that I provide you. Not only do you have the landlord and the tenant and the vineyard management company and the worker, but you would now then would have a union that you would have to navigate as well. And then the final risk, which I touched on earlier, is the tarnished brand with negative press. A lot of employment cases are threatened through publication, right? No one wants to be seen as a bad employer. No one wants to be seen as someone who takes advantage of the most vulnerable people in the community. So that is a real threat. And it's something that you should be cognizant of, again, in how you prepare your agreements, who you are preparing your agreements with. And that is it. I think there is a question.
Yeah, Carol, if you want to join us as well. We've got two kind of general questions. One was just if you have any thoughts on bottle pricing formula options in a lease agreement.
Yeah, that's a great question. I saw that bottle pricing, actually the easiest way to manage bottle pricing, the additional benefit consideration related to bottle pricing, is through trademark licensing. So if the grapes are associated with a trademark, having that consideration essentially run as a royalty is the best way to do it. It is probably easier in the vineyard lease context than a grape purchase contract if you don't have a trademark to associate with, because some of the Berry Hill restrictions are different, but the tenant is still going to have to comply with Berry Hill reporting, and that's really the crux of the problem of incorporating an enforceable bottle pricing provision, because you don't know when you're required to report the price that was paid for the grapes. You usually don't know the value of the bottle that those grapes are going into. So that is the challenge of putting together a bottle pricing mechanism that's enforceable. But you may be able to find easier ways to do that in a vineyard lease than the grape contract, but still the best way to do that is through a royalty structure for enforceability.
And we'll see if you can answer the next question. On average, how many billable hours should it take an attorney to create a vineyard lease contract?
Yeah, I don't think
that might be a little.
Yeah, I don't think I can answer that question, because it really depends on the vineyard lease and the negotiation and the parties. people always ask attorneys, do you have a form for that? Well, I have a lot of vineyard leases that I've written or that I've reviewed that other people have written over the years. But that doesn't mean that, I could say, all right, I'm just going to pull this one off the shelf and this one's appropriate for you. So, I'm going to take the names out of it in a half an hour and clear out the economic terms and give it to you. So that's really variable. It would be hard to answer and very specific. And it should be specific. When you're talking about real property, every piece of real property is different. And every single vineyard lease is different. And you need to make sure that you're working through those areas of distinction so that your contract works for you. And by working for you, hopefully what that means is you sign it. Everyone knows what they're going to get paid. Everyone knows what they're responsible for. And you never look at it again until it terminates. But, where it really needs to work for you is when the unexpected happens. And, have you given yourself enough guideposts to use that document to help you navigate those circumstances?
Right. If you could give an average, general, we won't hold you to it, but just curious.
Of how many hours it would take? Depending on the attorney.
Too many factors.
Yeah, depending on the attorney as to what they're starting from, if they're starting from scratch, what vineyard leases they have access to, whether they're good ones. I really don't think that I can answer that question. But you should talk to your attorney about it. Your attorney should be able to answer those questions when they have information.
Right, and they're more familiar with the.
Yeah, if you can say, here's the term sheet, here are the parameters. Can you give me an estimate? And attorneys will give estimates. They won't say, usually they won't say, this is going to cost you $2,000 or what have you. But that attorney should be able to give you an estimate based on the work that they've done before and, the specifics of the deal. But then where that negotiation goes, that definitely can change it. Sometimes everyone thinks that they know what they want until you write it, and then that changes.
Right. Well, I'll give another second to see if any other questions come in, but it doesn't look like it. So with that, thank you so much for the valuable information and discussion that went with it. To all attendees, we will send this recording out shortly, so don't worry, you didn't have to furiously write down on a pen and paper. And thank you, Carol, Jennifer. This was wonderful. We truly appreciate your time.
Great. Thank you.
All right.
Thank you.
Well, take care, everyone.
Bye.
Bye.